Hi everyone, welcome to the webinar. We are going to be discussing ethics in a pandemic today, the good, the bad, and the ugly with Professor Flowers of Stetson Law School. I'm going to give everyone a minute to log in from the waiting room, and that will also give me a chance to get the closed captioning up and running. So when the closed captions start, you'll see a red live box on your screen, and you can click on that to open up the closed captions in a separate window. And I will also post that link in the chat just in case you have trouble clicking on the icon. Well, the closed captioning is being a little slow today, but we will see it. All right, I'm gonna put that in the chat box, and then we will get started. All right, closed captioning is up and running. So welcome again, everyone, to Ethics in a Pandemic, the Good, the Bad, and the Ugly. I am delighted to have with us Professor Roberta Flowers. She is a professor at the Stetson Law School in Gulfport, and she is the interim director for the Center for Excellence in Advocacy, and also part of the Elder Law Center. She teaches ethics in an elder law practice, as well as evidence, criminal procedure, and professional responsibility. So I am so glad she could take time out of her busy schedule to give us a wonderful ethics training. This will be recorded, and I'll be monitoring the chat box and the Q&A box. And Professor Flowers is used to having students ask questions during presentations, so please don't be shy. Please get those questions in and we'll take them as they come in. And without further ado, I will pass it over to Professor Flowers.
All right, thank you. And I'm always excited to talk a little bit about ethics. So we're going to talk a little bit about the good, the bad, the ugly of representing folks in a pandemic. And of course, I couldn't start this without, at least giving you a little taste of the song. We're going to try to look at all of the issues that arise when we're dealing with a pandemic, but we're not going to be able to do all the issues. We're going to have to do just a few of them, and hopefully we can have a good conversation with regard to that. All right, so let's get started. So here are the goals of the session, because I think it's important for us to kind of understanding what we're really going to be talking about today. All right, so first of all, I want to recognize that possibly, and I'm going to take a poll in a few minutes, so we'll see what you all think. Possibly there's something good that's going to come out of the pandemic, right? That we're going to be able to reach more people, right? That people that might not be able to travel to our offices, we may be able to serve in a way that we've never been able to serve before. So that certainly is a good, right? And we'll talk a little bit more about some other goods that may be coming out of this pandemic world. We also, though, want to talk about the bad, right? And that is the issues surrounding communications through the computer, and most importantly, the issues of confidentiality. How do we protect the confidentiality of the conversations that we're having with folks when we are on a computer? So we want to think about that as we are talking through the rules with regard to confidentiality. And then I think the ugliest thing is assessing diminished capacity or assessing understanding. Even if we're not talking about a concern about diminished capacity, we still want to understand whether our clients are getting what we are saying. And so we're having to be a little more creative in how we are double checking with them to make sure that they're understanding what we are saying. Obviously, if we're talking with a mask on, we've got some real issues with regard to people that have diminished capacity from the ability to hear. But we're not with people very often, but we still want to be thinking about those issues. So the good, the bad, and the ugly of representing clients in the pandemic. just a few ethical ideas with regard to that. So I want to try a poll. Now, sometimes this works as far as you guys doing it, and sometimes it doesn't work. So let's just try it. You do it on your phone. And basically what you're going to do is you're going to text Elder Law Stetson 853 to the phone number 37607. And when you do that, you can then vote on one of these 4 things. Like, who are we? Lawyers with less than 5 years experience, lawyers with more than 5 years experience, non-lawyers with less than 5 years experience, and non-lawyers with more than 5 years experience, all right? So I'm gonna activate the poll, all right? And if you will just type into your phone 37607, and in the text box, you just type in law, stet, S-T-E-T 853, you'll be joined for the rest of the thing, and you can vote A, B, C, or D. So I'm gonna see if anybody votes and plays with me. If not, we will.
We have some people playing in the chat box, so I've gotten 2 A's so far.
Oh, okay. All right, so I got some A's. I got 100% being B, which means there could just be a person, one person or two. Oh, there, now we're going. All right. I'm always excited when it starts working, because then it knows, I know I did it right, number 1, and number 2, I know that there are some of you all that are actually, you know, listening to me, which is great, yeah. Right?
We got 2 A's and 2 B's via the chat box, so you can add those in.
Okay. All right, well, it looks like that we are looking at a lot of people with a lot of experience, unless those with less experience have just decided they're not going to vote this year. And so now I have to do my little political thing for the day, vote. Like vote, vote, vote. Every chance you get to just vote. So anyway, so we've got about 77% that have more than 5 years experience. We have about 8% that have less than 5 years experience on the lawyer side. And then we have some non-lawyers, which was even more important because I wanted to know whether we were going to have some non-lawyers on the call. And so it's good to see that we do have some non-lawyers. We got some more people voting. All right, we're only going to have a couple of these polls just for fun, but I wanted to at least try them out and see how that worked. All right. So this is always when I get a little bit difficult because for some reason it sometimes doesn't want to go forward for me. Come on, sorry about this. Oh, wonder why I'm not going forward. There we go. Okay, so hopefully some of you have seen the movie The Good, the Bad, and the Ugly. There are 3 characters. You can guess it, the good, the bad, and the ugly. And this is Clint Eastwood, and he represents the good. All right, so let's talk a little bit about how representation in this era is a good thing, why it's working well, why it's things that are good for us. So I think one of the things that we talked about just a few minutes ago was the idea that we are able to reach more people, that more people can access these, access our offices that may not have been able to in the past, right? People that couldn't drive, people that couldn't travel. And so that's, I think, a positive thing. I think another positive thing that's going to come out of this pandemic representation is I think we're going to be more competent, right? 4-1.1, we're going to be more competent with technology. And, you know, our rules were recently expanded to include competence with regard to technology. So I don't know about y'all, but I am becoming so much more competent at the use of technology. And the more competent I become at the use of technology, the more I become aware of all of the things that technology can do for me and for the people that I'm trying to serve, right? That I can do things that I might not have been able to before. I can do a mediation where I divide up people into separate Zoom rooms. So I think that there is this competency level that we are getting that we didn't have before, that I think is a positive for our clients. I think it's also forcing us to rethink how we represent clients. And I think that's a good thing. I don't know about your agencies, but I know our agencies here in the Tampa Bay area have been moving for years in trying to find ways that they can reach other people, right? So how can we have, for example, our elder law clinic, how can our clinic students go to the senior center and do interviews with clients and then be able to Zoom in or bring in by technology the lawyer if necessary, right? So with our increased competency in technology, we're also starting to rethink how we can use this technology in very effective ways. Finally, I think the word effective is going to be very important for all of us. We hate that we're not able to get together with people, to hang out at a conference, to talk to people at a meeting. And I don't think that all is going to go away. But I do think that we have learned to be a little more efficient with those kinds of things that need to happen, right? I think our courts are not going to go back and eliminate all Zoom hearings. I think there are going to be Zoom hearings in the future. Now, for paying clients, that's a really good thing, right? Because they're not paying for lawyers to drive down to the courthouse and sit in the courthouse for, you know, an hour instead of the attorney being at work, at the office. He signs on to Zoom, he does his hearing, and that's all he's charging the client for. So although for legal aid, that doesn't really affect us, but I do believe that it's going to begin to make us more efficient. I think our court systems are going to be more efficient. I think with their efficiency, more cases are going to get handled. So we're not going to have those long delays in trying to get results for our clients. And so I think at the end of the day, nobody wants to say, you know, there's a lot of good that comes out of a pandemic, because there's obviously a lot of bad. But I think for the court system, and I think for the representation of our clients, there are some good things that can come out of it. Now, we have to be open to that, right? And some of us old boomers are not as open to that idea of meeting with clients online, having meetings online, having church services online, right? Having court hearings online. Now, I got to tell you, I really don't know how trials are going to work. I will tell you that across the country, we're doing trial competitions. Those of you know that about Stetson know that Stetson is #1 in trial competitions in the United States. And we've had to adopt, because the competitions are now by Zoom. So we're at least getting some experience at the law school level at trying to do a jury trial through Zoom. But I do think we have to be, as practitioners and as supervisors and administrators of the office, we've got to be open to what are the good things that are going to come out of here. What are the good things that are going to help us in the future and help our clients, because we had to learn, right? Desperation is the mother of invention or something. I know I got that wrong, but something close to that. So there are some good things that are coming out of our pandemic. All right. So here's another poll. Tell me, do you think more people are having access to our services, right? So more people are having access to our services, true or false, A or B? So interesting. Okay, so what I'm hearing from private lawyers, you all are not experiencing it as much. So that's interesting. And And I'm wondering why, and I hate that I can't actually talk to you, but if some of you that wrote 85%, some of you that said false, we're not having more people have access to our services. Can you tell us in the chat room what has been your experience with regard to that? And maybe Christy could read some of those off so we can hear what you have to say about that.
Okay, so we've got some responses. We work largely with low income and homeless people. So that's difficult when you can't do in-person outreach at community centers.
Oh my gosh, that's such an thank you. That's such an excellent point, right? That if we're talking about homeless people, we're not talking, or people that are low income, they may not have the technology, right? Okay.
A lot of clients are not technologically savvy or don't even have internet. Another one, they don't have access to technology. Another one, lack of access to technology. And of course, Samantha clarified that that is the problem when you're trying to reach homeless people or housing insecure people. If they can't, if they don't have internet and you're not doing in-person outreach, they kind of don't know where to find you.
So
Yeah.
what is the answer to that? Is there an answer to that? Do we have some ideas of what we might be doing to be able to expand our services to those folks?
Let's see if that comes up. Someone else mentioned rural areas. Of course, that's also an issue. Some places literally just don't have good internet access. I know there's a place not far from me called the Green Swamp, and there is no cell reception, and the internet doesn't work there. So I'm very
Wow.
grateful that I can work from home where I am and have internet access.
Right. Yeah.
Another person
So
said limited access.
yeah. So is there a way for us to figure, and I don't know what the answer is, that's why I'm looking at all of you, for us to somehow bridge that gap? Because those of you that have been working at home know that we've got to figure out some way, because we're not sure at what point people will be getting on the internet.
Right.
Anybody?
Someone brought up something interesting about the age differences. Younger clients have more access because they have computer literate. Even if they're low income, they likely have at least a phone, if not a computer. Whereas the older clients may have lost all access. And that actually came up in our Tech Tuesday webinar yesterday about the digital divide. The presenter mentioned that the Lifeline program has been cut by 50%, which provided phones and data plans for low income people. So if seniors don't have a smartphone or internet, they really have lost all access at this point.
Yeah, and I'm so glad that we had this conversation, because one of the things that I'm hearing on the elder law area is that they have, at least at the private sector, have more work than they can really actually handle. That they're really faced with maybe younger generations getting their family members on there, their family members concerned about not having the documents that they need. And so they have seen a real uptick in the need for their services on the elder law side. So at least with those folks, the non kind of low income folks, they absolutely have seen a real increase in their services being used than less.
And some of our legal aid attorneys are saying that. They said we've had a lot of calls, so people are getting to them. Someone suggested meeting with clients in the office with a mask and social distancing. And someone requested something that you might be able to help with, Professor Flowers. She requested a better network or service listings of agencies other than legal aids who can help elder people. Is that something you have?
Absolutely. Send me, can whoever that was, send me an email to remind me of that, and let's
Yeah.
look at that, because I think we may be able to find that information, and that would be very helpful, I think. Excellent.
Perfect. And I'll email you and get that information to everyone if we have it.
Okay.
All right, that's it for comments.
All right. There we go. Okay. All right, so let's talk a little bit about how we then are going to deal with communication and confidentiality. I'm wondering if, for those folks that we don't have a computer, whether we also are thinking of phone conversations, phone conferences, the ability to have communications with our old clients, our clients that have been already into the offices, and then the new clients. And so we want to talk a little bit about when we are talking through technology. So we want to really have a kind of a conversation about how technology can impact confidentiality and our ability to communicate with people, right? So we want to talk a little bit about if we are able to talk to our clients, if we have clients that have access either through technology or through through computers, through phones, how do we make sure that we are maintaining that confidentiality that we need to maintain with regard to this? So we've talked first about the need for competence, the need to have the skill, the thoroughness, and the preparation reasonably necessary. So let's be real. I don't think any of us had any competence and any idea how to prepare for this pandemic, this issue of not meeting with clients except through technology, and therefore having a whole group of clients out there that we're not able to serve. And then those that we do have the ability to access with, when we're using phones or we're using computers, understanding the good and the bad of technology and how technology can help us, right? We now have the ability to do distance notarizing, right? Which we didn't have before, which certainly is one additional help. But we have to be competent with whatever it is that we're going to be using, all right? So the rule 4-1.1 actually added that we are required under Florida's law, in order to be competent, we have got to understand the risks and benefits of technology, all right? And I don't want to put a phone aside as a piece of technology. So we've got to understand what are the risks of using technology, what are the risks of using a phone call to make the conversation. For those that might use email, you know, what are the risks involved in using email? We've got to keep all of that kind of in the picture as we think about how are we going to move forward to try to get our clients back in touch with us and get our clients back able to be serviced by us in this world that we're not sure when it's going to completely open up, right? We're not sure when people are going to feel comfortable meeting with clients in person. I can tell you, for me, it's been a real struggle this semester. We're not having in-person meetings with students. All of our meetings are on Zoom. And so those issues are just different. They feel different, right? If I'm having to talk to somebody on the phone, maybe who doesn't hear very well, or I'm having trouble understanding what they're saying to me, how do I deal with that going forward? How do I make it better? All right. So let me ask you this question. I am concerned about confidentiality when I am using technology. Anybody? Wow. Okay, so confidentiality is something we want to talk about. Anybody want to share in the chat room, what are some of your concerns about confidentiality when dealing with technology? Am I getting any responses in the chat room?
They're just starting to come in. So we had one response. Samantha's concerned about who has access to it and where it's stored.
Right?
Who else is in the room besides the client? I've heard that a lot.
Yeah.
Oh, someone's having trouble with the poll. Someone else said sending emails to the wrong email is a concern.
Right?
If we have
Yep.
clients who don't have data plans on their cell phones, they may be sitting outside the library or somewhere public to be able to speak with us on Zoom.
Right?
Oh, someone said the poll is not open. Did it get closed already? All right, it's activated again in case anyone else wants to try to vote. And if you scroll up in the chat box, I typed in the text address that you can activate the poll on. Someone else mentioned that abusers might monitor the victim's communications and you would have no way of knowing about that.
Yeah.
The second person said that interception of communications through unsecured internet access, information on emails can be hacked.
Information that are sent to employers, if you've got an employer server, can be accessed by the employer.
Well, that's a good point.
Yeah, all kinds of great ideas. So let's talk about some of those issues and how we can possibly avoid some of them. And I'm going to say, I don't know that we can avoid all of them. I think that some of them are just a really difficult thing. But so you guys have kind of talked a little bit about some of these factors, but I want to talk to them with you directly and talk a little bit about some things that we want to at least think about. So the level of security afforded by the use of a particular technology, okay? We really saw that issue early on in the use of technology, especially once everything kind of closed down and everybody was using Zoom, right? And there were not as many, I mean, wouldn't we have all loved to have bought stock in Zoom in January of last year? But that's another issue for another day. But Zoom had to kind of come to the table and was having to fix security issues as they went along, right? So early on there, I know here at Stetson, there was a concern about using Zoom because of hackers, right? We were having, we didn't have any at Stetson, but other folks had meetings that people came into, you know, Zoom bombs. And so we were concerned about the use of particular technology. Now, I think a lot of those things have slowly gotten fixed, but we have to still be really aware of how secure that particular technology is. One of the things with working from home is that sometimes people get sick of working from home, and so they may take their computer and be working from the donut shop or Starbucks, right? And using the Starbucks Wi-Fi. Certainly have to be very careful and make sure that whatever system and software you're using on your computer is not opening up that information because you're using a non-secure Wi-Fi, right? So the idea of really thinking about the security that's afforded for different technology. The real other issue we always want to think about is the legal ramifications to a third party who intercepts access or exceeds authorization of that information. You all raised it, right? You have an abuser that's in the house, or you even have a family member that's in the house, and you're sending information to an email address that other folks have access to. You want to be very clear that the information that you are giving to your client is going only to your client or to people that your client has agreed that they want to share that information with, right? So we want to really think about, is it available to other people, and how could those other people possibly use that information to the disadvantage of our clients, right? So the idea that if an abuser is at home and you're sending information about a temporary restraining order, and that information could be actually accessed by the domestic violence abuser, that's got some very, very significant ramifications, and certainly something we want to think about in this new world of electronics that we use a lot. And that comes to the second one, right? How sensitive is this information? Obviously, if I'm saying, I'll meet you at this first time, or I'll meet you at this time, or here's the, here is where you can get into my Zoom room so we can have a conversation. You certainly want to think about whether that information is going to then allow somebody who doesn't need to be in the Zoom room into the Zoom room. That's why most of us now, well, Zoom actually put it as a default, there's a waiting room and a passcode. So those kinds of things to do, so you make sure that if it is sensitive information, you are in fact being aware of that, right? The possible impact of an inadvertent disclosure, all right? So some of you talked about what we used to call the Freudian fax, but of course nobody faxes anything anymore. So, but the email that goes to respond to all when you only meant it to go to your client or even opposing counsel, right? I mean, there are things you're going to say to opposing counsel that you don't necessarily want the judge to be reading, right? So one of the things that we want to keep in mind with emails, especially, reply all should not be something you do very often, right? Like I have my default to be reply. So unless I specifically push reply all, it's going to only be reply. And I think that's a really important thing that we're being reminded of now that we're doing so much by technology, so much by email. We definitely want to be very careful about string emails, right? That you're sending this piece, but you forget that in the string that was with the other folks that were still part of that thread, there's other information that you don't want to divulge to that person. And so even though you're not replying all, you're replying from that reply or from that thread that has several different people on it. And that means that that person gets all of the conversation all the way down to the bottom. Now I'm going to tell you, there's a lot of people like myself that end up never reading all the way to the bottom. But I can also tell you that I have had a lot of time, not a lot, please, not a lot, but occasionally when I've made that mistake and have forgotten that I'm just emailing Mark, but I'm emailing him from a thread that had a whole bunch of other people. I'm replying to one person, but it's on a thread that has all of the other people on it, that all of that information is there. And some people do read all the way to the bottom of the email. So you want to be very careful with reply all. You want to be very careful with replying even to one person in a thread that's all reply all. I think your default should be a new email each time that you're starting a conversation with somebody or you're continuing a conversation with somebody and you're moving from everybody to just the one person, all right? That's going to be especially important when you're talking about sensitive information. Let's say, for example, your client had come in with a family member. They had agreed that the family member could have that information, but now you're in a thread with them that you're not sure that this is all information they would want to go to a family member. You're going to want to be very careful about using a thread that includes all of those family members when you only want the information to go to one person, all right? Obviously, the urgency of the situation, we may pick up the phone in a location where we wouldn't necessarily use a phone because of confidentiality issues, but there's an urgent need for us to get in touch with the person. But we have to be very, very aware, and I know all of you have experienced this. You're standing in the courthouse and there are 3 lawyers talking on 3 different cell phones, obviously talking about a specific case. Now, it may not be a case you know anything about. It may be a case that nobody doesn't know anything about. But it also could be a case that just by hearing that, confidential information is going to be elicited, right? I walk by and I hear the attorney saying, well, Mr. Dillman, we're going to file the petition tomorrow. Well, Mr. Dillman is my husband, and I'm not going to be happy that Mr. Dillman is talking to a divorce lawyer about filing a petition tomorrow, right? And so we want to be very cognizant of the fact that cell phones have much more security than they had many, many years ago. But they don't have any security if I'm in the courthouse having the conversation, if I'm in the public having the conversation. That's equally true when we're talking to our clients on the phone. We need to know where they are at, and who else is there, so that we can understand who they are allowing to hear this conversation, right? Because the truth is, if in fact they're allowing other people to hear that conversation, then the conversation is no longer privileged, right? So you may be getting the subpoena if there's a need for you to testify as to that conversation, and you will not be able to defeat the subpoena because there was a third party involved, all right? We obviously want to think about the client's situation, the client's instructions, the client's circumstances. If we're using email and we're using Bobby Flowers' Stetson email account, the truth is that Stetson University College of Law owns that server and therefore has access to all that information. And so we want to be very aware of that when we are emailing clients, if in fact they're using their work email. All right. So again, the conversation with them for them to understand the importance of confidentiality and how that can be broken if in fact they're using a server. All right. So we've talked a little bit about emails. We've talked a little bit about Freudian slip, but you guys raised a really important issue. And I will tell you, it's an issue that is really being discussed in the elder law community, especially, right? Because we all know in the elder law community, there are issues with regard to undue influence, right? From kids, even well-meaning kids that are trying to force their parents to do something. And so we've always taught you are going to have a meeting alone with your client in order to make sure that you are A, assessing their capacity, and B, being able to make sure that what they are saying they want is really their objective and not somebody else's objective, like one of their kids who's unduly influencing them. Well, as you sit there right now and you look at me, you have no idea who else is in my house, right? You have no idea whether my son, who has been trying to get me to change my will for the last 6 months, is sitting right next to me, or whether, my abuser is sitting in the other room. So that becomes a real issue, both when you're talking on the phone and when you're using technology. Now, different people have made different suggestions, right? The first is obviously just to ask the client, is there anybody else in the room? And then to have the explanation about how that presence of that other person can be detrimental to the case, because first, it will make there not be attorney-client privilege, right? And second of all, that person may use that information. Or third of all, somebody else might use the fact that that person was in the room to show there was undue influence for whatever situation the client decided to do, right? So that idea of how do I figure out whether the person is alone? Well, the first thing is to actually ask them. The second thing is, and I'll tell you, some lawyers are actually asking their clients to kind of rotate the camera around, kind of like, oh, let me see what the rest of your house looks like or whatever, to make sure that the person is actually alone. And the most important thing, and you guys all know this, I don't even need to say it to you, but document, 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 right? You want to document that you asked that question. You want to document that you did what you needed to do to try to determine whether that person was there or not. if need be in the future, right? But at the bottom of it all, right, we can't know whether there'll be somebody there or not. So sometimes if you have any inclination that in fact there is somebody there, it makes sense to advise with regard to confidentiality, right? Sometimes we forget that merely asking somebody, well, do you want this person to be in your be with you? That's sufficient. It's not under our rules. Under our rules, under the Florida rules, we have to actually get informed consent. So we've got to explain to that person what are the benefits and risks of having somebody else involved with the conversation. Happens a lot with elder law, can happen with estate planning, can happen with a variety of things where the person is uncomfortable coming to see you or talking to you, and so they're including or bringing somebody else along. Once I have done kind of my advisement as to confidentiality, and that person still says, I really need that person here, then the second step for you is to have them articulate why they need that person to be there, because you want to document that they were a necessary part, which is one way to defeat the argument that there is no attorney-client privilege, is to say that that other person was necessary to the representation. But if you haven't asked the question, so I asked the daughter, or I asked the mom, why does the daughter need to be here? Well, because the daughter does all of my business, all my financials now, and I don't really know much about it, and she needs to explain it to you. Okay, I probably have a necessary person, necessary to the representation. I then can document that to save the attorney-client privilege if the issue comes into a problem. Now, I understand your clients are not going to be particularly wealthy, obviously not, because they have to be low income, but you still don't want to have a problem where brother and sister decide they don't like what happened and now they start fighting. So being able to kind of document that information and advising the clients as to that information, I think is going to be really helpful, especially when we're talking about being virtual and I can't see exactly who is in the office or who's in the house with the person, or who's sitting next to them outside, or who's at the Starbucks with them, wherever they're at when they're having the conversation with you. It's important to remember that our rules do find a violation even in inadvertent disclosure. So you can't say, oh, well, I just made a mistake. I didn't mean to send that email. That doesn't excuse the disclosure, that inadvertent disclosures are considered to be a violation of confidentiality also. Christy?
Yes, we did have a question come in about students and law school emails along the lines of that. The person said, it sounds like we should be mindful of having any client-specific discussion with an intern who's using a law school email address, unless it's fair to say there's a level of assumed privacy between the school that owns the email server and the individual student accounts.
That is such a great question. That is such a great question. I'm going to suggest that it's probably going to be kind of under our umbrella if they are working through a clinic program or an externship program within the school, that the school would then be mindful of any confidentiality issues with regard to, because the student would be considered to be part of the attorney and therefore would be under the attorney-client confidentiality that would be saved even though they're on the server. So, you know, I want to look that. I'm gonna research that and get back to you guys on that, because that's a really interesting question that I don't know that I've ever even thought about, strangely enough. I think that our insurance writer for the students, and I believe our school has memorandums of understanding, MOUs, and usually that's going to be covered under the MOU, but certainly I'm going to go back and look at our MOUs and make sure that it is, and then I'm going to send you guys just like a little idea about what you might be thinking about with regard to that.
Okay, and I think a lot of the legal aids have law school volunteers that are outside of a clinic. I could be wrong, but that's my experience. Just,
Yeah, they're doing like
random law students
confidentiality
reaching
stuff.
out. Mhm.
I would tell you if they're outside of the, now, here's what we're going to say. Most law schools are not going to be the least bit interested in that stuff, right? The, usually that's more of a problem if it's an employee and there's information that's coming from the lawyer to the employer that might impact his employment. But even having said that, I think probably I would be very careful not to divulge any confidential information in an email to an intern that's using the law school's server unless I had it in the MOU with regard to that. So there can be MOUs even when it's not a clinic, but I certainly would be very careful about what I'm putting in that email because I do think that there's an issue with the fact that, not that it's going to come to fruition, but there certainly is an issue with regard to the information belonging to the person that owns the server.
Okay, and hopefully that will mitigate any potential malpractice suits, which someone put legal aid malpractice does cover certified legal interns and pro bono attorneys, but hopefully we can prevent it from getting to that level.
Right. Yeah. Yeah. We don't want to be calling our malpractice insurance.
And one more suggestion, it might be a best practice to give volunteers and interns a law firm email address while they're working with you.
Yeah, that's a great idea. That solves the issue completely. All right.
That's it.
Yeah. So just a couple of other things we want to think about, and this one, these three are probably not very important from the perspective of the workplace monitoring and the confidentiality within the workplace. But I want to broaden it a little bit, and I want to ask if we've been talking about office policies regarding the protection of information um, on the internet and technology, right? It happened so quickly that I know most offices that even have really strong policies and procedures haven't caught up yet with what should be the procedures with regard to that. A few years back, the big issue was we had staff people and even lawyers. I don't want to exclude lawyers from that, who were using Facebook and other social media that was divulging confidential information. There were lawyers that were friended by courts that shouldn't be. So the question becomes, do we have an office policy with regard to the use of technology? I just think it's really important in these days that the people that are kind of in charge of those policies go back and look at them and make sure they're clear with regard to what kind of technology you're going to use, what kind of technology you're going to use for certain situations, what kind of technology you're going to use in other situations, and kind of just review those policies. First of all, I think what's going to happen is when reviewing those policies, you're going to find that the policies you come up with are even going to be better even once we're back in the offices. But certainly during this time, we want to be very aware of, are we training people and do we have in place policies to make sure that our confidential information is being stored? We all know that confidentiality is one of the bedrocks of our representation. And so we want to keep looking at how that can be impacted negatively at this time when technology is so much an important part of our representing clients. I'm going to skip through the confidentiality rules. I think we probably all know them pretty well because I want to make sure that we get to what I think is one of the difficult things going on right now, and that is the ability to assess the capacity of our clients and to assess their understanding of what we're saying to them and what they need to do to move forward. Even in the best of times, I think assessing capacity and assessing understanding are difficult. And I think they just become even more difficult when we are using some form of technology. When we're not person to person, we're not being able to look them directly in the eye. A lot of times they'll be looking other ways because this whole camera thing is odd. And so the idea of how do I make sure that A, they have capacity in those clients that may have marginal capacity, and two, how do I assess their understanding of what I'm saying to them when I'm not having that kind of give and take? You know, I'm having that issue today, right? Because I want to have a give and take with you. I want to know what you're thinking, where you're going, and I'm not able to do that. Now, obviously in a Zoom call, you are able to directly talk with them, but there's still that issue of really trying to kind of assess where they're at, right? So for example, one of the things that a lot of times when we're assessing somebody, we're going to be looking at their hygiene. We're going to be looking at how they're put together, right? Not an indication that they're absolutely incapacitated just because they, you know, have their shirt buttoned wrong, but it's certainly something that we use to kind of say, hey, you don't look like yourself today, right? How are you feeling, right? So having that ability to really assess those issues is much more difficult in this day of technology meetings, all right? So some of the things we want to learn to ask question-wise, okay? So how do I look to confirm the person is understanding what I'm communicating to them, right? So the rules tell us that we have to communicate enough information so that the client can make an informed decision. Well, communicating information doesn't just mean talking at you, right? It's communicating with you. And so how do we figure out whether A, the person has the capacity and the ability to understand, they have the capacity to make whatever choice they want to make, but also are they taking in the information that I'm trying to give them, right? We assess people's capacity, even though we may not do it intentionally, but we're assessing people's capacity and understanding every time we communicate with somebody, right? And especially those of us that are dealing in the area of mental health issues, or we're dealing in the area of the elderly issues, we're constantly trying to assess whether this person today and at this time is able to understand me and is able to make the decisions they want to make because they have the capacity, all right? So we know what we have to do. We know we have to explain it to them, but we also need to think about how do we, A, come up with ways to explain to people and assess capacity, and B, what can we do to maximize the capacity? What are some things we can do to help people, even in technology, to be able to understand what we're talking about, right? So we know that capacity generally is on a spectrum, right? That it's not like an offer on switch. It really is a dimmer switch, right? And so there is total capacity, there's incapacity, and we know there's a lot of gray in between. There's a lot of people's cognitive issues that may find them incapable of understanding enough to make the decisions that they need to make, right? We know that a lot of times capacity can be situational, right? Some people sundown, right? Which means if you talk to them at 4 o'clock in the afternoon, they're not going to have the capacity, right? If we're talking about a homeless person who had one meal today and it was at breakfast and hasn't had anything to eat since then, he may in fact not be have the capacity to make the kind of conversation, make the kind of decisions that he might have had right after breakfast, right? And it's transient, right? It's not an all or nothing. It's going to come and go, right? My friend Ed Boyer always says it's like a lava lamp, which I'm probably going to have to stop using in a while because so many people don't even know what a lava lamp is. But, you know, kind of the ebb and flow of the lava, which is kind of like what we talk about when we're talking about capacity and understanding, right? I can sometimes look out at my 75 students in this gigantic room with their masks on, and I can see it in their eyes that they have transitioned to another world, right? So we've always got to be looking for that, looking for capacity issues, looking for understanding issues, and much more difficult in today's world. Our rules tell us that clients with diminished capacities may have periods of lucidity, right? If they have not been declared incapacitated and they don't have a guardian, they are authorized, therefore, to make decisions for the client, all right? A client with diminished capacity imposes a higher burden on the attorney. And I think you take that and you add to the fact that we're having to do a lot of these meetings through the technology makes it even more difficult, all right? Rule 4-1.14, I have to give you some rules or you won't get credit for CLE for ethics. So here we go. The client's ability to make adequately considered decisions because of mental disability or other reasons. As far as possible, we want to maintain normal client relations. We all laugh when we say normal. Like, do you have to have a normal client to have normal client relations? Do you have to be normal to have normal client relations? We know that normal client relations really entail communication, loyalty, conflict-free, listening, those sorts of normal client relationships, all right? And obviously, in some situations here in Florida, we can seek a guardian if we need to. And I will tell you, guardianship hearings are being held on Zoom and have continued throughout this whole, you probably know, this whole pandemic. Again, the comments again remind us that this is not an all or nothing proposition, that there are intermediate degrees of capacity, and that some people that have diminished capacity can still do some routine things, but not do the more complex things, right? So here's kind of some things we want to look for as we are talking with our clients about the decisions they want to make, right? And really being maybe even more intentional than we might have been in person. First of all, can the person make the choice? Are they able to make a decision, all right? Are they able to explain to us the reasoning for that choice, right? If we have known the person for a while, are their decisions consistent with their history, or are they doing something that's kind of inconsistent with what we've seen them do in the past? Or they come back into our meeting and the things that were so important to them the last time we talked have not become important to them anymore. Now, that's not to say they lack capacity. They may have lacked understanding as to what you were telling them, or they could have changed their mind. But we've got to be alert to it and kind of think about it and have the conversation with them. Does the person repeat questions or information after a short period of time? All right, that's a sign of some dementia, some cognitive impairment. Can the person, after you've told them what they need to do next, can they list back for you what they need to do next, right? So have they written it down? Have they had the capacity to write it down? And have they had the understanding to understand what you need them to do? I think more and more, because I can't hand them a piece of paper, right? I can't be in my office jotting down things that are going to help them, some suggestions I have for them, and then hand them that piece of paper. I've got to make sure they took it in orally, right? Now, there are some abilities on some technology to use whiteboards. I haven't found them to be a particularly effective with clients in technology. My elder law attorneys don't seem to think it's that helpful, but at least it gives you the ability to somehow give a visual to them, all right? Is the person having difficulty coming up with the right word? That could mean a variety of different things, but it's certainly something to note and think, are they getting the understanding that they need? Does the person use the wrong word? Ask the person if they can summarize what you've discussed. Can the person change subjects? Can the person do basic calculations? All of these are ideas of ways for you to assess understanding and capacity when you can't be face-to-face with the person. You're having to talk to them on the phone, all right? Does the person get easily disoriented? Is the person emotionally stressed out? Because a lot of people are emotionally stressed out right now. And is that why they don't seem to be getting the understanding of what you're trying to help them with? Or do we have a real capacity issue? Are they acting emotionally? Now, a lot of people act emotionally and they're perfectly understanding what's going on. So you can't just, use that as the sole factor, but it's certainly something that you want to be cognizant of as you're talking to them. I have heard from elder law attorneys, one of the things they do is they're taking more time, they're slowing down, and they're actually taking breaks and saying, okay, let's rest for a second, let's kind of take it all in, because there's not the same kind of human touch that we have when we're in person, all right? Decline in grooming or hygiene. Is a person experiencing hallucinations? That's an easy one. Well, not very easy, but it's certainly one you would be able to tell. And does it seem that they are talking about things that are rationally based, all right? Here are 3 references. I'm going to just leave you with these. These are all, one is for lawyers, one is for handbook judges, one is for psychologists. They're all really good. They all have worksheets in them. So if you are routinely doing diminished capacity assessments, the worksheet in the handbook for the lawyers is a perfect checklist to get you to think about the things you need to think about, to get you thinking about the questions you may want to follow up with. The one for judges, a lot of judges are trained on that for guardianship. So if you don't have that, all of these are free for download from the ABA or from the APA, American Psychological Association. If you want the actual pretty book, you can get it free from the APA. The ABA charges us. I won't say anything about that. But anyway, great references, right? You can find it on the ABA website or you can find it on the American Psychological website. Both really good diminished capacity. Now they talk about older adults, but it's for any kind of time you're trying to check the capacity of your client, all right? Real quickly, I've just listed a few things to think about when you're thinking about how can I increase their capacity. These come from the NAILA aspirational standards. Conducting the interview at home, that's not going to be possible, but certainly at a time when the client is most alert. Gradual client counseling, a series of shorter interviews, shorter decision-making, varying your communication style, using appropriate visual aids if possible, hearing enhancements if needed. Obviously using the language that clients understand, either by using a translator or by using a deaf interpreter, and providing other reasonable accommodations that might be requested by the client. So you tell the client, look, if you get tired, let's stop. We can come back to this another day. We don't have to continue. I don't know about you, but Zoom meetings are exhausting. And so we need to be cognizant of that when we're dealing with clients through technology. Oh my God. So I leave you with this, right? The good, the bad, and the ugly. Seeing the good without being overwhelmed by the bad and the ugly. I think this should be our theme for the pandemic, right? Looking for the good, looking for what good might come out of this, and not being overwhelmed by really the issues that we can't control as best. So I know I went a little long.
No, thank you. That was wonderful. Thank you so much. I was just thinking the whole time, this is by far the most interesting and helpful ethics CLE I have ever attended in my 10 years as an attorney. So thank you so much.
That's very nice. Thank you.
We had a lot of compliments come in.
Do we have any questions we need to cover?
Yes, we all wish we could enroll in your class, but second best is doing questions via chat. So we had one come in and it was talking about making sure clients are alone when you're talking to them virtually. The person asked, what could we mention to our clients regarding confidentiality when we are interviewing, counseling, and following up by phone? Is there a certain script you recommend?
Yeah, I recommend a couple of things. I recommend that for your checklist, the things you want to make sure they understand is, number one, that there's this thing called privilege, which means anything that we talk about, nobody else can find out about. But if you have somebody present, then you don't have that kind of confidentiality and other people could find out what we're talking about. Number two, I suggest that you talk to them specifically about, and I usually suggest you do it kind of kiddingly, Like, oh, I know your kids would never, or I know your wife or husband would never do this, but I have heard of family members finding out about information, overhearing information, and using it in ways to hurt their family members. I know none of your family members would do that, but you just need to be aware that that can happen. So kind of those two pieces, the privilege piece and the confidentiality piece, that it can be used against them, I think is really important. Even if you don't see somebody else there, you could just kind of have the conversation like you've had the conversation before.
I like that, and it doesn't put them on the defensive, if you do
Right,
it.
right.
And then
And I suggest that even if their kids are present, like, oh, I know that
yes, definitely, especially.
Kyle would never do this to you, Miss Flowers. I know he's a good son, but have I heard of some other sons that weren't so good, right?
Yes. The next question is about third parties. So if the person has inquired and asked and make sure there's no conflict and done their due diligence and advising the client about confidentiality, and then during the conversation, the third party brings something up that may conflict with the client's position, do I stop the conversation and require that person to leave?
Absolutely.
Okay.
Yeah. Yeah, you want to be very careful once you see that that other person has a different view of something than the client, because you don't want to have happen where, I mean, you don't want to have happen that this person suddenly believes that they're your client also, and now you've got a conflict and you can't represent both of them. So that's why you have to make sure you say, I'm sorry, I thought I explained this, but I didn't explain it very well, I guess. You're not the client, and it sounds like you have some other interests. It'd be best if I talked with your mom or your dad or your husband or your wife separately, because I can't advise you because you're not the client. So reminding them that they're not the client and then asking them to vacate. And of course it's tough, right? Because you could tell them to vacate and they could be sitting right over there in the corner. So
Yes. Well, I thought we had 7 new questions, but it was just 7 new compliments of everyone. Thank you for an excellent presentation. And one of your former students, Peter Bradshaw, gave a shout out. I feel like I got this in all of Professor Flowers' classes, so lucky him. And Professor Flowers has generously agreed to share her PowerPoint with us, so I'll send that out tomorrow with the recording. And I did want to announce the CLE number for anyone who's listening by phone or who is visually impaired. I did put that in the chat, but just in case, the number is 2006 038, N as in Nancy. Again, it's 2006 038, N as in Nancy, and it's approved for 1 general and 1 ethics CLE. So thank you again, Professor Flowers. I
you're
think we
so
all
welcome.
enjoyed this and we really appreciate it.
All right. You're welcome. Have a good one.
Take care, everybody.